35, 45 people already signed in, 53. Your honors, you're very popular. So are you, Jason. And I would say, Gary, you might be a real popular guy. Or William Penn over your shoulder.
I think I'm the guy
85. I want to say, Gary, I don't think I've ever seen so many people sign up so quickly. Wow, we've over 100. All right, I think that's enough of a critical mass for me to introduce myself and some of you great folks to the Magna audience here. I'm coming to you live from Exit 4 off the New Jersey Turnpike. Jason, that's a New Jersey thing. You probably heard some of the late night guys making fun of us. I love my exits in New Jersey. Exit 4, but I grew up on Exit 9, which is much better exit than 4. Totally different world. Anyways, I'm coming to you live from my bedroom. This is my new office. I've been moving around from week to week. Last week, I was in my little home gym, but you couldn't see because I had a digital background. We've got a great webinar, another free webinar for everybody that's attending today. And I just wanted to take an opportunity to give a little introduction to the folks out in virtual land, because we can't get out there to see you. When I say we, Dan Paletti, he's our senior vice president of sales at Magna Legal Services, and Lena Egan, one of our directors of business development down in the Miami area. Lena tells us that there is COVID down there. So I say, I hope you're wearing a mask, but what I see in the news is a little bit different than what we're hearing here. But up here in Jersey, we're all got our masks on. I just came from Indiana. Like I said, Gary, everybody was wearing their masks. It was bittersweet. I dropped my son off at IU, but really getting back to us here at Magna Legal Services. So for those of you like Judge Burke is looking at me right now saying, what's going to happen next? I just want to tell a little story about who we are. We're actually celebrating our anniversary, Gary. We're 14 years young this month. So 14 years ago, we planted a flag in Center City, Philadelphia, to create a company called Magna Legal Services, which it was designed and is designed to provide services from discovery to trial. And I thought, Dan, it would be a nice opportunity, instead of me blabbing away, maybe you could just give a little plug for what we do and why the folks out in virtual land might want to reach out to you or Lena in the future.
Yeah, absolutely. So, we are a national provider of litigation, consulting, and support. We do everything from discovery through trial. Obviously, we have Dr. Rachel York Colangelo here today, who heads up our jury consulting division. She's busy in her team running focus groups and mock trials and venues all throughout the United States. We do the online focus groups. We also have a damages assessment tool as well called Jury Evaluator. We've seen that a lot of our clients have been contacting us to do jury evaluators to help them resolve cases much earlier on, and also helps during mediation as well. We have an ALM award-winning graphic consulting and design team. Really, we're not just the designers. We'll help you with recommendations based on our experience, and we have the folks that pull it all together as well. We have a trial presentation unit that will build the electronic database with all of your exhibits and run the multimedia presentation. And that could be for any type of legal proceeding, like obviously like a trial, virtual trials, arbitrations, and mediations. We have a cyber surveillance group that will scour the internet and hundreds of social media websites to find information on just about anybody you're looking for. And then on the front end, we have a discovery services group. So we handle national court reporting. So we're doing all those virtual depositions, especially for Gary Sams. I know he could attest how great of a job that we do. We pride ourselves in helping attorneys manage the hardest thing about virtual depositions, which is the exhibits. We also have a translation and interpreting division as well, and medical record collection. So with that being said, that's kind of Magna in a nutshell.
Oh, Gary, that was a mouthful, huh? Lena, I think you could have done that even better. Lena, you're based down in the Fort Lauderdale, Miami area. Do you have anything you want to add to that?
I think Dan pretty much covered it all, but we certainly are happy to get started and happy for everyone to join us here today. And I will turn that over back to you, Peter.
Yeah, so I'll say this. Well, the one thing that Dan left out, Gary, is that we don't charge for the virtual services. That's right. We are the greatest enablers of the legal or the judicial and legal services world right now. We are not charging for the depositions when you utilize one of our court reporters. So the virtual platform, whether it's Zoom or it's Blue Jeans or it's WebEx Cisco or Microsoft Teams, We are technology agnostic. We'll work with you to make it happen. And we've been doing that, Your Honors, for bench trials as well as the arbitration. So, we've actually conducted several bench trials with the virtual platforms, and we've made it really, really relatively easy for folks that are afraid of technology, afraid of programming a VCR that doesn't exist anymore. I mean, that's the world that I came from, but we really make it easy. So I just want to thank you all for taking the time. I want to thank you, Dr. Colangelo, for joining us, Jason and Judge Burke and Judge Rogers, and most of all, Gary. You really put this together, and Gary's just an amazing trial attorney. He's participated in many of the Magna conferences that happen in the bricks and mortar environment. And by the way, everybody write down October 7th. God willing, we'll all be at the W in South Beach, because that's where God wants us to be at the next Magna conference. It should be a lot of fun, and Gary will be there. And so, Gary, I pass the virtual baton to you, and thank you very much.
Thanks. Welcome, everybody. I will say, just for the advertisement purposes, Peter, I've been nothing but satisfied with all the good work Magna does. But I'm extremely fortunate to be here today. I was asked to help out with this webinar, and I was very fortunate to get two of the best jurists in Pennsylvania that I've had the pleasure of appearing in front of or trying a case in front of. They are, as far as I'm concerned, the highest compliments that you can give a judge is that they're honest, hardworking, and fair. And that's certainly what these two judges are. So we have Judge Burke, who is on the Court of Common Pleas in Luzerne County. He's been on the bench, I think, since he was appointed by the governor in 1998. He's the former president judge up there, and I think he's the most active judge on the Luzerne County bench, that's for sure. So thank you, Judge Burke.
Quite welcome. Glad to participate.
Judge Rogers is similarly an excellent judge that I've had the pleasure of being in front of. He is the administrative civil court judge, I think, in Montgomery County currently.
Yes.
He's been on the bench almost 20 years now, and he's had chances to yell at me as well. So, Judge, I want to thank you for participating. The only thing I'd say about Judge Rogers is just a longtime public servant. He was chief of police in Lower Providence Township before going to law school and while going to law school, and continues to serve the citizenry of Montgomery County all the time and all he does. So thank you, Judge Rogers.
My pleasure. Thank you.
Jason Newton, who is also on the panel, is the Senior Vice President of Curie, a nationwide insurer dealing mainly with medical malpractice and related issues. He had a very successful practice for a number of years before joining Curie in 2013 or 14. He's a senior fellow with the Litigation Council of America and has had experience supervising counsel all over the nation, as well as actively trying cases himself. So, Jason, thank you for participating today.
Thank you, Gary, for having me.
And then, of course, Rachel Colangelo, Dr. Rachel Colangelo, excuse me, Rachel, is here from Magna. She's here to give us the viewpoint of, from a jury consultant's perspective. She has participated in and conducted research on what we can expect from COVID jurors. So essentially what we're going to be talking about today, everybody, is what can you expect during a pandemic, during a jury trial? And we hope to get perspectives from jurors, judges, lawyers, and litigants. We'd love you to give us your questions as we progress and tell us what you think is going on, or hopefully we can answer anything you have a question about. So I guess just to kick it off, guys, I'd like to know, we know courts are opening in Philadelphia in March, hopefully. I know that Chester County is starting with civil trials again in February 16th or so. And I think, Judge Burke, you guys are trying up there in Luzerne County to get trials started again. So generally, could you tell us what to expect, Judge, initially, as far as any changes that we might see?
I think we had a trial run with all this in October and November, whereas some of the larger metropolitan counties, Philadelphia and probably Allegheny, had to shut down because of the scale of their operations. But we were able to identify venues that were large enough to conduct jury selection with social distancing. Believe it or not, first trial under these arrangements, I presided over a trial where we chose the jury at the Mohegan Sun Arena, which is an ice hockey venue, a concert venue. But it was for a substantial medical malpractice trial. We brought in at least 80, maybe closer to 90 prospective jurors, and everyone was quite pleased that they were kept at a distance. Ultimately, we got down to individual voir dire and had arrangements with special rooms and breakout areas to do things like that. But it's going to be more of the same in the month of March and April as we work our way back into the production of handling trials. So perhaps Judge Rogers, they have a slightly larger county, and I don't know what approach they've taken.
Judge, what is happening in Montgomery County? I know you guys are watching a little bit, trying to see how everybody else does, getting a little bit of a later start. Could you share some things with the folks watching?
Sure. We're kind of at a perspective point of view. We have not had any jury trials since March. But what we have done is over the months, we had for every Thursday for months and months, we would meet at 7:30 in the morning, the judges and the other constituents, the attorneys and staff, court administration. And we developed a protocol for how we were going to handle the jury trials, everything from selection process down to changing the questionnaires, to amend the questionnaires, to deal with COVID issues and things of that nature. We were about ready to start the trials in the second or third week of January. And of course, that was when the surge hit. And so we've already purchased all the equipment that's needed, and all our courtrooms have been fixed with the necessary equipment, from the plexiglass down to the basic sanitizers and things of that nature. So right now, we're now doing this again. Actually, we're meeting every Wednesday at lunchtime now, trying to put the finishing touches on this thing. So just hoping that the circumstances will change for us to implement it then.
Well, hopefully, at least you get a free lunch now, at least with. But
if I might emphasize a point, Gary,
please.
What's most important for practitioners is know your locale. One size does not fit all. And whereas we use the large venues to select a jury, we bring the trials back to the main courthouse, but within the courthouse, we're hoping not to have more than 3 trials at one time. And we have the courtrooms set up with advanced communication technology, screens, audio, and plexiglass, all the safeguards. But it's very, very important to understand your logistics before you begin the trial process, the jury selection process, I should say, and then to not be caught off guard with anything.
I appreciate that, Judge. I want to talk about the logistics in a minute, but first I wanted to get Jason's input on what he's been able to observe. I don't think they've actually had many trials nationwide, but at least you do business nationwide, Jason. What are you seeing?
Yeah, well, as I had shared with the group before today, Gary, in my world, Pennsylvania really is an outlier in terms of in-person civil trials, multi-day civil trials actually taking place. We've seen a lot of other jurisdictions try to start and then pause and then concede that they've had to stop. We've also seen jurisdictions encouraging litigants to consider a lesser number of the maximum available jurors on a panel. We've seen attempts to start virtual trials. We've seen that in New Jersey recently. There was talk of that in Georgia. And we've seen, for example, a court in California suggest to the litigants that they choose between a bench trial and a virtual trial. So we've seen a lot of experimentation. We've seen some folks in our cases that might not ordinarily be interested in talking about arbitration, talk about arbitration in venues where historically that is considered, just because of the lag between when trial had been expected and when it's likely to occur. So that's some of what we're seeing nationally, Gary.
One of the things that I know we're seeing locally is, for instance, in Bucks County, they strongly encouraged the litigants to accept a jury of 8 instead of 12 and 2. So far, that is the only county that was that enthusiastic about it, at least in my dealings. And I know that up in Lackawanna County, they got an emergency order from the Supreme Court to limit the amount of preemptory strikes that were allowed. I'm wondering if, Rachel, you and the judges could share with us what you think that does to the jury trial and whether we're going to see that continue.
Rachel?
Sure. I'm happy to chime in first on this. It's been interesting. My experience has been that the number of peremptory strikes has remained the same in most jurisdictions, but we are hearing talk about potentially limiting that, as you said, Gary. I think litigants will not be excited to hear that, because I think the feeling on both sides is that if we are not able to strike those jurors who we feel are going to be unduly prejudiced, biased against our given client, that is going to result in juries who are not as neutral as perhaps either side hopes they would be. So some of the limitations that people are having to adjust to because of COVID, limited time for voir dire jury selection, for example, conducting voir dire in a stadium when perhaps you can't even see the jurors very well and everyone's wearing masks. All of that makes it difficult to judge or ascertain the fairness of a potential juror in the traditional ways that we would, looking at body language, facial expressions. So we're having to adapt. I think that Judge Burke's comment about being prepared for those adjustments is key, meaning we all know that things are going to be different. And I think that it would behoove lawyers to sort of accept that it is going to be different. We're going to have to approach things with a new strategy so that you're not sort of left scrambling going, but this isn't how I'm used to it. This isn't fair. I don't like this. It's sort of, okay, we've accepted it. We're moving forward and doing the best we can.
Judge?
Yeah, if I might, I will interject with a question that was posed with respect to the juror return. In order to gather approximately 80, 85 jurors, we had to send out over 800 summons. So it's about a 10% return as of September and October. I don't know what it will be this March. At any rate, I would say for the more substantial cases, the medical malpractice cases, the large trucking accident type cases, and so on, generally, the litigants and counsel strongly prefer the 12-person jury. That collective judgment of 12 individuals having some input. On your lesser cases, and no jury trial is unimportant, for heaven's sakes, to the litigants, it's their case. But for your slip and fall and fender bender type things, if they do go to a trial, they'd perhaps be more amenable to a smaller jury, 6, 8, and so forth. But that's my assessment of the idea of. Now, one area where there might be some flexibility is with respect to reducing your number of strikes without taking all your peremptory challenges away, to suggest that we have 2 defendants, would you take 2 each and the plaintiff has 4, or even the plaintiff take 2 and each defendant take 1, particularly if you have a poor turnout with your panel. So you have to be somewhat adaptable to take advantage of having your case heard.
Gary, if I may, also, in terms of the whole jury selection process, we're going through this vaccination period of time now, where the people that are going to be first on a list, so to speak, are those that are 65 and older. And So one of the issues that is going to come up in jury selection, I anticipate, is the elderly people generally want to be jurors too. You're going to have those people that are vaccinated on the jury, and so you're going to have a potential gap in the ages of who you can pick for purposes of jurors in this case, and where you may want someone that's younger that may not be available to you, and certain other characteristics. So the whole pandemic situation, and now with the issue of the vaccines and the way they're going to go, presents, I think, some real challenges to jury selection potentially.
I think you're both right, and I wanted to follow up on that with respect to, do you think it's fair, or do you foresee your counties attempting to force people to proceed without preemptory strikes? I still think that the Supreme Court's order would be challenged, despite the fact that it came down from the Supreme Court. I think there's serious issues with it, some due process issues, but I'm wondering what your counties are doing and what you've seen with, is there really a difference between 12 and 2 jurors or 6 or 8 jurors? I have always done it the defense way and requested as many jurors as possible. Obviously, that's just more they have to persuade if you're looking for 5/6 in Pennsylvania. But I'm wondering what you guys have seen as far as whether it does make a difference to the litigants, the number of jurors. When Judge Baldy was encouraging everybody to go to 8 in Bucks County, when he was having his hearings and questioning people why they insisted on 12 and 2, that was the main question he was asking. What difference does it make? Can you prove to me what literature is out there that has changed this or that justifies such a request during these times? So, Jason, I'd like your input on that on what you've observed. So, Judge Rogers?
Well, I think it depends on what type of case it is, Gary, to be honest with you. I think there will be a lot less resistance to going down to 6 or 8. If it's an auto negligence case, a slip and fall, as Judge Burke was talking about before, that's where it's going to come down to. I don't see an issue. I see our county being resistant, however, to reducing the peremptory challenges from the very get-go, and would solicit the attorneys for their input on that, whether they were willing to do it, but certainly not force the issue. I just don't see our judges forcing the issue.
That's great. That's good. Jason, what have you seen?
Yeah, I think, Gary, we certainly advocate for and ask our counsel to insist upon the maximum number of jurors available for the reasons that you articulated. And I think, we shouldn't focus on that too much as the dispositive feature of how to try a case in the COVID era, because there are so many other things involved. And I think, as the judges have alluded to, when you have a 2-week or 3-week medical malpractice trial, there's a significant amount of non-refundable expense that's going to take place in advance. And so, one of the things that should be considered is for trials that should attempt in-person proceedings is how many litigants are involved, how many people are required in the courtroom for the testimony, are experts coming from out of state, will there be virtual accommodation for people who might need to testify from remote locations, the length, the number of days of trial, and then, the limitations for all practical purposes on how many people can congregate in the courtroom. And I know, for example, because we were involved in one of Judge Burke's trials, there was a limit of, I think, 25 people per a local ordinance in terms of how many people could be in. And so that's something, once you get 3 sets of lawyers, a jury of 12 plus alternates, the judge, the courtroom staff, you may have people that have a legitimate reason to be there who can't because of local ordinances. And so those are the things that we're trying to process and consider. In truth, we'd rather be nowhere other than a brick and mortar courthouse right now trying cases. I mean, we're as frustrated as everybody else with the backlog of cases that are accumulating, but we're also willing to be patient because we don't want to take shortcuts to compromise ultimate justice.
Rachel, I think that the judges and I all have anecdotal evidence of what we believe makes a difference in a jury trial. Does the number of jurors make a difference to certain defendants or plaintiffs?
It absolutely can. And it is also very dependent on whether a given jurisdiction requires a unanimous jury verdict. So as you pointed out, Gary, in Pennsylvania, it's 5-6. So if you've got 6 jurors, you only need 5 to agree. If you've got 12, you'll need 10. There are some venues that require a unanimous verdict, and the litigants will take that into account. It's much harder to get 12 people to agree than it is to get 6 people to agree. Just the numbers make that more difficult. Stereotypically, a plaintiff might want that smaller group because it's easier to get a smaller number of people to side with the plaintiff, who might be seen as an underdog. You've got that sympathy factor, versus the more people you add, from typically from a defense perspective, the more chances you have of somebody at least holding out and saying, wait a minute, let's take a step back. Let's look beyond sympathy as they are instructed by the judges. So it definitely varies depending on the fact pattern and the rules as far as the jury deliberations go. But a defense, as Jason pointed out, more often probably wants the maximum number of jurors because it makes it more difficult for a plaintiff verdict.
Now, one of the judges mentioned, I think very appropriately, that the composition of the jury is going to be a little different. I think there's some people typically, and I think I saw in your research I was looking at, that there are certain types of jurors who do not want to volunteer now. And so I want the judges first, and then you and Jason to comment. Does that affect significantly the verdicts we can see, both as far as plaintiff and defense verdicts and the damages that we might be talking about? Do you see the composition with those that are afraid to come to COVID or those that aren't afraid of court? What do you guys think?
It's going to be interesting as we get into the month of March and see what the developments are to ascertain whether the vaccination factor is going to be in any way impacting on the willingness of jurors to serve and the way they will look to one another generally. This is a new element now, and it may have a bearing in some unforeseen way. So the other thing I would go back to is, I don't know, I'd love to share the historical perspective of when we began with 12-person juries generally in this country, but it's been that way. When I have done juror orientation to the jury pool, 200, 300 people come in on a Monday morning. This was pre-COVID, of course. I would always say to win them over as to how important their role would be, the collective judgment of 12 individuals from various walks of life far surpasses, in most cases, the most enlightened judgment of a single individual. And where you have 12, I think there's a better balance and a more reasoned verdict that will be rendered. But the situation is not infallible. I understand in Florida, for example, they conduct trials with 6 and 8 person juries routinely. So I don't know whether it's tradition and custom that weighs so heavily in my observation, but it's a real factor.
Do you see a change in the verdicts or the damage awards based on the number of jurors? For instance, if there's more jurors, do they tend to reason one another out? Or is there more fear of a runaway if you've got less people to persuade? That type of element. You see that coming into play?
I would defer to those who track these things, Gary, more than my own assessment. I will tell you that we've had 7 or 8 civil trials in Luzerne County during September, October, and early November. And generally, there were a few surprises with verdicts that were a little higher than people expected. And there were a number of defense verdicts, but it's each case stands on its own merits, so it's hard to generalize.
Thank you. Judge Rogers, do you have anything on that topic?
Well, we're as part of our protocol for the jury trials, when we bring them into effect, we've decided that we're not going to put any pressure on any person that comes in for jury duty. We have a system in Montgomery County where it's a one trial, one day. Our jurors can come in for 1 day. If they're selected for trial, they then go for that trial, and then they're done for a period of at least 3 years. And so what we've placed in our protocol is that if any person comes in for jury duty, expresses any type of fear whatsoever or any reluctance to coming in, they would be excused and they'd be eligible to come back in 6 months as jurors. So we wanted to keep that, any fear, any concern that any person would have. And we've prepared a letter and so forth that would go out ahead of time to all those people, alerting them of that fact. And so clearly we took the position, we don't want anybody there unless they want to be there and feel safe to be there.
Yeah, I think I mentioned during a discussion that we had previously that I was on trial 2 weeks ago in Northampton County. We had 49 potential jurors. I asked the question during general voir dire, is there anybody that felt uncomfortable being there due to COVID or thought they would be unable to concentrate because they'd be worried about their health? Not one of the jurors, not one of the 49 potential voir dire raised their hand. Now, I think as Judge Burke indicated in our conversation, that might have been because they selected everybody out ahead of time. So you only got those willing to sit. But I think, Judge Burke, if you're only getting 10% coming in, can we function with that many, with that few responding?
Well, I think Judge Rogers raises a very good point. We, in fact, have adopted the Montgomery County approach with the pandemic, such that the panel, the pool essentially becomes a panel for a single case in each instance. So the previous practice, pre-COVID, if you will, had been to bring 200 to 300 in at one time and then divvy them up as the week played out in different panels. But here, going forward, I suspect we may follow the Montgomery County plan somewhat uniformly.
Jason, do you have a concern trying cases in front of a COVID jury? And if they are, what are they?
I think the main concern is, like I said before, Gary, putting expense into a trial that gets derailed midstream, and that wastes everybody's time. And it's not good for the plaintiffs, it's not good for the defense, and it's not good for the courthouse personnel. So we actually would love to be trying cases. I think the main concern I've got is just the judge being comfortable and the attorneys being comfortable with the protocols that are in place, with things as mundane as who is going to wear a mask, is there going to be uniformity, is the mask going to be clear over the mouth, are witnesses going to be allowed to take off masks, and under what circumstances, so that there's the same rules apply to everybody. I think that's my main concern.
Judge Burke, I think you've tried a couple cases, you said, in the fall. What was your experience with the masks and what did you allow?
Well, the primary objective was to have masks worn most of the time, with certain exceptions. And that would be with counsel making opening statements, closing arguments, and the court giving its charge with lengthier aspects of the trial. But on the other hand, on occasion, you might have one or more witnesses who simply were not able to project adequately for the jury, which is spaced out throughout the entire courtroom. There are only 4 jurors in the traditional jury box, and there were 8 others dispersed. And incidentally, we had 4 alternates for that one substantial case because of the concerns Jason touched on, to not want to get caught short if you fell below if you develop some problems. But at any rate, I think you can have your general guidelines, but there has to be some ability to adapt if you have someone whose voice is muffled coming through the mask and the jury raises their hand and says, we can't really understand what the witness is saying, and so on. So,
and while we don't always look to Northampton to be the leader in progressiveness and the like, when I was up there, they did hand out clear masks. This is mine left over from the court trial up there that the courthouse paid for, bought, and during voir dire, they gave all 49 potential jurors a clear mask so that we could see their expressions, judge them on that. And then they gave them to every witness as they testified. They gave the mask, the clear mask that they bought at their own expense. I don't know what you guys are looking to do as far as that goes, Judge Rogers, but in addition to that, Judge Rogers, I know that New Jersey recently came down with an order that has saying each county now may decide to force a juror to try a case to trial by Zoom over the party's disagreement or failure to consent. Do you see anything like that happening in your counties, judges? And Jason, what would be your opinion about being forced to do a Zoom jury trial? Judge Rogers?
Yes, I read the article in the American Bar Association about that, and where right now it's kind of on a trial run, I believe, where there's 4 or 5 counties that they're doing this on, and then I think effective April, it's mandatory, and for all the counties in New Jersey. I don't see anything like that in our county being instituted. From a practical standpoint, in Jersey, they're issuing tablets to all the jurors. Just the expense of that alone would probably be prohibitive for us to even do it. But purely from a fair trial standpoint, forcing someone, as Judge Burke had said previously, the importance of a trial is to everyone who's involved in the case, a litigant, and that's in some cases is one of the most important days of their lives. And I think to impose those types of restrictions is just is not something we want to be doing.
Yeah.
Anything on that, or Jason?
I wanted to let the judge go first. So, Judge.
No, I share Judge Rogers' sentiment, but we're in uncharted waters, and if indeed the pandemic transitions into an endemic element here of any proportion, such that the ability to conduct significant numbers of live trials is impeded, then maybe we'll visit the matter further. I see where New Jersey seems to have some pilot counties where they're going to test this out and then make it binding on April 21st.
Yeah, Gary, I'll
just
weigh in. You know, we've obviously read with interest.
You're on mute, Jason. Actually, it's the best thing you said all day.
Sorry about that. Hey, sorry, I can't remember what I said now. So, you know, we've seen some experimentation with hybrid virtual trials. So maybe, you know, some people are physically brought into the courtroom. That would certainly be, while not, you know, optimal, better than a completely virtual trial. And I'm sure we've all read stories about the trials that have taken place for commercial litigation where jurors are seen to be lying in bed, obviously working on other things, texting, their phone, doing work emails. You know, we all now, almost a year into this, understand that people multitask when they're on video conferences, and we're all in overdrive. And that's not a desirable situation for a jury where, you know, Judge Rogers or Judge Burke could, number one, instruct the jurors not to do any research out of the courtroom. You know, they're just to hear what the witnesses are going to say, and that's limited, the information that they're limited to having about the case. But also they could reprimand them for inattention or sleeping, and that's really not possible in the virtual environment.
And I don't think any of our colleagues, our lawyers watching are going to select Jeffrey Toobin or anybody for sure. But so there's obvious problems with it. But one of the things I wanted to ask about a hybrid approach, and Rachel, I want your opinion on this as far as what do you think, how receptive it would be to jurors. And a lot of experts that I use are out of state. When they come in, we have quarantine issues in Pennsylvania currently. I have a trial starting March 1st. I can't ask my expert to come in and quarantine for 2 weeks before testifying or whatever. So are we going to see hybrids where the parties testify live, everybody else is by Zoom? What effect does that have? Or even does that give the defense an advantage because now there are experts who normally wouldn't make it to trial to watch a plaintiff's expert testify, can now watch it on Zoom for an hour or two, and they would be better prepared to address it. And is that fair? So it's a compound question, but why don't you illuminate us?
Sure. No, it's a good question. And that is what we are seeing play out in trials that we've been a part of over the past year. Is this sort of hybrid seems to be working actually relatively well, having the jurors and the actual parties in the courtroom together so that you've got control over the jurors' environment, what they're doing, their level of attention, but then allowing witnesses to be zoomed in, if you will, so that you don't have to deal with the quarantining for 2 weeks or exceeding the number of people that are allowed into the courtroom. And some of our clients have asked, is this a problem if we've got a critical expert? Or what about my corporate representative? What if they testify via Zoom versus live? Is that offensive to a jury if we're not able to bring our corporate rep into the courtroom to speak to them? And what we've actually heard from jurors is that there's no offense taken, that they completely understand that we're in uncharted territory and that honestly, this is being done for their own safety. I think a lot of what has made these hybrid approaches successful is the instructions that the judges are giving to the jurors to sort of explain, this is why some of the witnesses will be on television and not in the room. It's for everyone's safety, not because they can't be bothered. So I think that's important that the jurors have that context and understanding. We've heard from jurors that they actually love the Zoom witnesses because they can see them up close and personal, if you will. A lot of these courtrooms now, you bring in a huge TV for the jurors to be able to see the witness on the Zoom feed versus in the courtroom, the witness may be on the other side, in the witness box, and the jury might be seated in the gallery. We're seeing a lot of that for social distancing. And the jurors have commented they can't hear the witnesses very well. They can't see the witnesses very well. So in some respects, it might be preferable to have a witness come in via Zoom feed rather than in person and risk that the jurors are going to miss that critical expert testimony.
Judge Burke, in any of your trials, did the experts or did you see an increase in people testifying by videotape or Zoom?
I won't say there was anything out of the ordinary. We did have a couple witnesses with videotape depositions played back in the courtroom. But I follow all of Rachel's analysis with respect to, particularly with regard to experts, where you might have some difficulty with the quarantine issue.
If a litigant, and Judge Burke, Judge Rogers, I'd like your input on this. If a litigant insists that I want to bring my expert in live, I think it's the only way I can convey what I need to on behalf of my client. Would you force them to do it another way if they were out of state?
Would probably need to know more information as for the basis of why they feel that their expert would have to come in live. Clearly, from a strategic standpoint, though, having your expert testify live, albeit not under these circumstances, maybe necessarily during a pandemic, I believe over the 18 years I've been doing this, that has more of an effect than using the video. There's nothing worse in a medical malpractice trial as a judge to look over during a video after lunch sometimes, and you see that there is really not too much attention played on that particular expert testifying in that video, quite frankly.
And I think we all too often look at it as just the advantage that the party has who's putting the expert up about the expert being alive, being live. But I believe it's much easier to cross-examine somebody live in the courtroom than it is on videotape. Those moments of hesitation or silence or where it gets choppy, they can be played through, or it's tough being aggressive when you're not in the same room as somebody. You can't gauge how the jury reacts to cross-examination that you're asking, so you don't know how far to push it. So I think it's better for everybody, just not the presenting party, to have the person live. And that's why I would do all I could to even avoid bringing anybody in by Zoom or on tape. Jason, have you guys had experience in that?
Yeah, I mean, our experience is consistent, I think, with particularly what Judge Rogers is talking about. You don't want to bring in a canned for-trial deposition to play for the jury. You know, it is intriguing to think about the more interactive type of scenario that Dr. Colangelo is talking about, where the witness is live, you know, everyone is in the courtroom live and you're interacting. My suspicion is that would be more engaging for the jury, and we're all a little bit more comfortable with that and the idea of it these days. But our preference would be in person based on the feedback we get post-verdict, the research that we've done.
Sorry to interrupt. Go ahead, Judge.
One of the important things is perhaps with your local government officials, your courthouse safety group and so on, to have relaxed protocols for out-of-state expert witnesses, so long as they can, this is an evolving situation, so long as they can demonstrate that they've had their 2 vaccinations, for example. Do they get more latitude? We had a few obstacles back in the fall, not in my case, but some others, where someone showed up and came down from Connecticut and thought they were going to just move right in, and ultimately they did pass through security, but that's something to pay attention to.
No, I appreciate it. Now, I did see somebody sent a question. I don't want to ignore our audience, asking about how do you prevent the inappropriate contact with, for instance, a lawyer or somebody else while you're doing these trials by Zoom. And we all would love to think that no lawyer would be involved in any of that. But unfortunately, I know we saw there was a recent case up your way, Judge Burke, a little north of you, about an inappropriate contact during the Zoom deposition, maybe whispering answers. Is there anything we can do other than asking attorneys just to be officers of the court and proceed appropriately?
Well, this is where Magna or other providers might come into play. Is there a way to get a panoramic view of the room from which the witness is giving his or her testimony?
That's an excellent point.
Yeah, there are a lot of things that we can do with technology. I think that's very astute for you to, assume that we can. For example, there are cameras now that are called the Owl. And what it does is it delivers both a panoramic view of the room and an up-close view, as we have, for example, for the 5 of us, so that you see the person's face, that you can also view what's going on in the room around them, so that no one could be in the room. If they have a phone, that they're using to text with counsel off-site, that would be visible. So there are things we can do with technology. We've also recommended to clients that are using us for virtual depositions and hearings that they stipulate ahead of time to a lot of these points. So if you are concerned, like Gary said, we would hope that no one would be acting unethically, but maybe that stipulation where you're laying out all the ground rules and just making it explicitly clear, no communication, no notes available, all of those things, at least they're in writing and all of the parties have agreed to them ahead of time.
Judge Rogers, I can only imagine if somebody got caught doing that in your court.
Well, it's interesting because the New Jersey proposal, where the jurors will be at their homes, part of the language of the order by their Supreme Court says that they will, that the jurors should recognize that the judge has the ability to somehow do a panoramic review of the jurors. And so they put them on notice of that. And so obviously that was a concern that they thought about in that regard. But I think certainly an instruction by the judge in writing, so there's none of this, well, I didn't think this or I didn't think that, should be given to the attorneys ahead of time before they do that. That's how I would handle that.
Yeah, I think that's great. I would like to see, it would be great if all of the courts could invest in these out cameras. It sounds very helpful, which I want to raise. We have a lot of issues that unfortunately we're not going to get time to get to. But I did want to raise the issue of, everybody talks about the trial. What kind of appellate issues can we expect because of some of the procedural or substantive limitations as a result? Judge Burke, I happen to know one of your cases is up on appeal. I don't want you to ask you to say anything you can't, but in general, do you see appellate issues that come kind of hand in glove with the COVID issues?
Let me interject. One, there are post-trial motions pending. Neither case that I tried in the fall is on appeal at this point. But that said, I will speak generally. Fundamental fairness is the guidepost. And that is a function of informing counsel and the litigants as best one is able to do beforehand. This is not a perfect arrangement, but it affords you the opportunity to proceed with the trial if you so choose. And there are many, many plaintiffs who are anxious to move their case to trial and proceed within some known ground rules, and be prepared to do a breakout if necessary to cover something that was unanticipated.
Well, I think as Rachel said, letting things get done in writing. So I'm wondering if, for instance, the configuration of the courtroom, where people are seated, if we can encourage parties strongly to stipulate to that so that we don't have to worry about those types of issues becoming appellate issues. Mm-hmm. Judge Rogers, you said you guys are looking at a number of protocols currently to go forward with your trials, and you have the benefit of being kind of not behind everybody, but doing it, following some folks. Do you have any protocols or thoughts in line on this?
Not on that specific issue, Gary. One thing I was going to say is Jason had mentioned something about, if I could just step aside on a different subject real quickly, about Please. The mask. We're doing, even though we're not doing jury trials, we're doing bench trials, quite a few of them. And one of the biggest challenges for a judge, I think, and Judge Burke may agree with me, is the record and how the record is maintained, particularly when people are wearing masks. The constant challenge to the court reporter in terms of the mask and the muffling and everything like that. But I expect that there'll be some records made on trials which maybe we're not in the best of circumstances, where we saw a lot of dots across the transcript indicating unintelligible or something like that. That could be an appellate matter when it goes up on appeal, in terms of the record was not properly done because of that.
That experience.
I was going to say, Rachel, before we let Peter get back in here and take over, I'd like to get a comment kind of from each of you, if I can, wrapping up on one kind of words of wisdom you can offer our audience. Rachel, you want to go first?
Sure, I'll go first, and I just want to sort of piggyback off of your question and the responses about some of these appellate issues that I think also respond to a few of the questions that we've gotten from the attendees about the makeup of the jury pool. There was one question in particular: are litigants getting fair jury trials if there are people who cannot serve or are not willing to serve due to COVID-related issues? And that's something that I could see as an appellate issue. We have a lot of clients asking us that question: do juries look fundamentally different? And if so, are they somehow less neutral or less fair to either or both parties? I won't spend a ton of time going into these details, but we are seeing some differences right now in-person jury trials, but maybe not the way that people would expect. For example, a lot of our clients are expecting that retirees, the folks that are perfect for juries because they don't have the employment concerns or childcare issues, might not be showing up. We have actually not seen that in practice. We are seeing the 75 plus age group being a little more hesitant to appear in person. That may change as everyone gets vaccinated, but we've actually seen younger jurors, and political affiliation has a lot to do with willingness to serve on jury duty, sort of your general philosophy about COVID. We're seeing that the courts are doing a really good job of handling COVID anxiety and COVID health concerns ahead of time so that that doesn't need to be addressed in the courtroom or in the stadium, wherever you're conducting voir dire, but that there are many COVID-related hardship issues that are precluding jurors from participating more so now than before. And the judges mentioned that they're being a little more perhaps lenient with folks who are bringing up these hardship concerns. No one wants to be the judge or the litigant that forces a juror to serve when they are having a legitimate hardship, whether it's childcare, I've got kids at home doing virtual learning, or I've been laid off, I just got my job back. So it's those types of people with sort of the financial and the other hardships that might be less likely to serve on panels right now. So again, it might be affecting the character of juries in a way that is surprising and people wouldn't expect. But I do think that's a potential appellate issue if people feel like, hey, the jury pool that we had was not representative. It was not a jury of peers.
Jason, final perspective from a litigant standpoint and or an attorney standpoint before we go to the judges?
Yeah, just one thing, Gary. The only thing I haven't mentioned, perhaps on the list of ways to creatively deal with the pandemic in jury trials attempting to be had, is to consider bifurcation. So we've seen at least one indication that a judge in Pennsylvania is thinking about that. That's certainly done as part of routine practice in other jurisdictions where we operate.
I think that's an excellent observation. Judges, would you consider bifurcation, and your last thoughts?
Judge Burke?
Yeah, I'm not categorically opposed to that, but most often I find that the litigants prefer to get to the bottom line.
Okay. Any final words for us, Judge Burke, on your thoughts as far as what we can see going forward? I know you were concerned about different variants that might be coming.
I don't think we can presume anything. We really have to be vigilant and adaptable to change in circumstances. We hear the mantra, follow the science and be guided accordingly. I think most judges have concerns about some of the routine things that we would do in ordinary times, such as sidebar conferences and this sort of thing, try to minimize those. But the important thing is that counsel be informed. Don't hesitate to have more than one pre-trial conference. One such telephonic conference might be dealing with logistics only. And the important thing is to keep the lines of communication open and endeavor to afford the litigants an opportunity to have a fair trial.
Thank you. Judge Rogers?
The only other thing I would add is that this is a very stressful time for most people, and it will be even more stressful in some certain cases for people, even more if they're subjected to jury duty. And so we as judges have to be concerned about that and not encourage people to have those feelings. And as we said before, if they are, for whatever reason, are having this fear about serving as jurors, they should be allowed to not serve under those particular circumstances.
Well, Peter, there you go. We got to about a third of the topics we wanted to discuss. We're very fortunate to have this very well-informed panel. And I'm sorry we didn't get to everything, but thank you, everybody, for your contributions. That was great. Peter?
Gary, outstanding. Jason, fantastic. Dr. Colangelo, you're always amazing. And Judge Burke and Judge Rogers, thank you very much. Gary, there is a thing in the new Zoom land as in a sequel. So, if you want, we can plan a sequel to this because it really was a great topic. It was a great discussion. I stopped myself from Zoom bombing a couple times when I wanted to throw a couple of things out there. So I controlled myself, and by the way, I haven't been Zoom bombed by anybody yet. So listen, if you're looking at the chat bar right now, one of my folks is going to be pasting into the chat bar the Magna registration link for our courtroom reopening tracker. What that means, Gary, is that every Monday we update the tracker, and you can get an email from me, yours truly. I'll send you a nice email. I'll tell you about what's going on in my life in the first 3 sentences. I'll share all the key highlights across the country of what's opening up and what's closing down or what's experimenting with hybrids and virtual. And then I'll give you the full spreadsheet of every venue across the country. So you get plenty of data, but I do try to chunk it up into the salient points for you. So I got Dan and Lena back with us. We just want to give one last thank you to everybody that joined us today. And if you have any virtual deposition needs, which you need to work up your cases with depositions, Gary, to take them to trial, and you're down in the South Florida area, contact Lena Egan. If you're in the Northeast, this guy, Dan Paletti, by the way, Judge Burke, he goes by Depo Dan. That's his nickname in the legal circle. He's Depo Dan. Call Depo Dan. You can reach us all at 866-624-6221. And if you call and you ask for Gary Sands, we'll transfer that call over to Gary. Thank you very much, everybody. Thank you. We appreciate it. Be safe.
Thanks, everybody. Be good. Be well.
Thank you.